Canada's top court has weighed in on the increasingly controversial issue about the duty to consult with Indigenous groups. The Supreme Court says that federal ministers don't have a duty to consult First Nations before they draft legislation. However, a majority of the justices say there is a less precise requirement that still needs to be met. The CBC's David Cochrane has the latest from Ottawa.
This is a challenge that was brought by the Mississauga Cree First Nation, which is an Aboriginal band with a traditional territory in northeastern Alberta. And their challenge was against environmental laws that were brought in by the former Harper government in 2012. And their argument was that those laws infringed upon their traditional hunting, trapping, and fishing rights. And as such, they should have been consulted on this legislation as it was being developed. So they argued that the duty to consult applied to the drafting of legislation and to the legislative process. They won that at the federal court. It was overturned on appeal at the Federal Court of Appeal because the ruling was that the federal court didn't have jurisdiction. And today the Supreme Court was unanimous on that point in throwing it out, arguing that the federal court did not have jurisdiction. So it lost on jurisdictional grounds. But because this dealt with this issue of duty to consult, the Supreme Court felt it was important to determine whether the duty to consult applies to the legislative process. And they've given a 7-2 decision on that, saying that it does not, essentially ruling that federal cabinet ministers do not have to consult Aboriginal groups when developing legislation. It's a balancing of constitutional rights, and essentially what the Supreme Court has ruled is that it would be too much of an intrusion into parliamentary privilege, into the supremacy of Parliament, judicial intrusion into the legislative process, potentially creating scenarios, Andrew, where you could have legal challenges on a piece of legislation every step of the way as it's moving through Parliament, and it would sort of force the court into a role of a supervisory role of the lawmaking process. They felt that that was too onerous, too restrictive, and a violation of the rules of Parliament under supremacy. So they ruled that this argument to expand the duty to consult did not have any merit on legal grounds and on jurisdictional grounds. So they lost on 2 important points there.
But there's a second ruling in this case, right? That's important to talk about too. Tell us about that.
Yeah, just because they don't have a duty to consult, it doesn't mean the government is off the hook. There was a 5-4 decision arguing that the honor of the Crown applies here. So no automatic constitutional duty to consult on the drafting of legislation, but there is a legal and constitutional principle that the government of Canada has to deal honorably with Aboriginal groups and respecting their rights. For example, Trans Mountain, that's an executive action. That is something the Prime Minister and the Cabinet can do without the approval of Parliament. There's an ironclad duty to consult on that. Using the honor of the Crown, you couldn't use a legislative process which is exempt from the duty to consult to get around that obligation. So they must act honorably in all ways. Specifically what that means is going to take more cases and more challenges and more precedent to properly define that, but no duty to consult, but a duty to act in good faith and act honorably and acting in the best interest of the principle of reconciliation with First Nations.
And with CBC's David Cochrane in Ottawa. For more reaction to the court's judgment, let's go to Vancouver. Perry Bellegarde is the National Chief of the Assembly of First Nations. So, National Chief, what was your initial reaction to the court's decision?
Well, initially, again, we looked and we upheld first the leadership at Mississauga Cree for challenging this 2012 misguided piece of legislation, the omnibus bills that impacted on our rights, on inherent rights, on Aboriginal rights and treaty rights. So when it first came down, we also saw that it was a divided opinion. It was 7-2. And so it was 7-2 that there was no duty to consult and accommodate when legislation being drafted. But then as well, we also acknowledged that in the 5-4 decision that the honor of the Crown must be upheld. And that's a very important piece, that the honor of the Crown must be upheld. So even in the sense that when you look at the entire decision, that if they do develop laws that impact in a negative way inherent rights or treaty rights, there is compensation that's going to be owed. There is restitution that should be owed. And we don't want to get there. So the message to me is to governments, sure, in the drafting of legislation, they don't have to consult First Nations people. But I think the rights lens, the Aboriginal rights lens, the treaty rights lens should be used in drafting those just to make sure there's no big, costly, timely, big fight in court when it comes to our rights and title. And so that's kind of the message to me now, that governments must work with us in a good collaborative way to get good laws and good legislation to uphold and maintain the honor of the Crown at all fronts. That's how I interpret it initially.
So the government argued that requiring consultations with First Nations before making laws would be impractical. What do you say to that?
Well, again, that's their determination. Interesting to note that it wasn't a unanimous decision at the Supreme Court. It was 7-2. So there was no unanimity on that front in argument either. And that, again, the upholding the honor of the Crown, it even comes to legislation. So when you read the dissenting opinion, focus on that piece, that it wasn't unanimous. And so it was a 7-2 decision. And so, of course, the Supreme Court of Canada, we respect that. But the message more openly is that to governments, that if they are going to draft any legislation for potentially impacting on treaty rights, inherent rights, or Aboriginal rights, that they use that rights lens to avoid costly fights down the road. Because it also was clear in their decision that if laws are put in place that impact in a negative way our rights, that there will be remedies sought. And so the message is, let's not go there. Let's just get this done in the first place. And so there is the honor of the Crown. There is the obligation to do things in a good way. And I think if you do that, you're going to get better legislation, not only for First Nations people, but for all of Canada. And that's really what it's all about, building a better country together.
But when you hear deal honorably with Indigenous people, I mean, it's not defined. I mean, is that open to interpretation, and do you worry about that?
Well, again, the honor of the Crown. We've said the Crown has not respected inherent rights or Aboriginal rights or treaty rights for over 100 years since we entered into the first treaty relationship. If we're going to build a better country, we always say we have some good tools now. We have the United Nations Declaration on the Rights of Indigenous Peoples. And that really is a roadmap to reconciliation in Canada. And so if we're going to build a better country together, let's use the tools we have, and that's one of them, because it speaks to free, prior, and informed consent when anything is being developed for Indigenous peoples. And it also speaks to the point that in Canada you have common law and you have civil law. But there's also a movement now to respect First Nations law, or Creators law, or natural law. And there's got to be space enough for that in this country called Canada. And I think if we can do that, there is respect for the jurisdictional piece that First Nations always say. We do have the right to self-determination. And as the right to self-determination, we can develop our own systems, culturally, economically, spiritually, the whole gamut. And so I think that's in that spirit. So in the sense that people say, oh, it's a Supreme Court 7-2, First Nations have lost. To me, I look at it in the vein of that other piece 5-4 about upholding the honor and integrity of the Crown. And that the Crown must operate in an honorable way. I'm going to keep focusing on that aspect.
What do you think this means for, what this ruling means for the Trans Mountain Pipeline expansion project?
Well, I think what it means is that, again, the most important right we have is the right to self-determination as Indigenous peoples. And because of that right to self-determination, it's the right to say yes and or the right to say no. And that should be respected. Because, again, you cannot mitigate the killing of a people or the pollution of water and land where it's just totally irreparable. So you have to respect that right. And that's the position going forward, the right to self-determination. And it's going to be up to the rights and title holders to make that determination. And it's up to them. Their self-determination, the right is to say yes and or no. And I think the best way for people to get to a decision is build a respectful relationship first before governments, federal government, provincial governments, and our industry try to build anything. Build that respectful relationship with Indigenous peoples first. And you're going to, 9 times out of 10, get to where we all want to go, balancing the environment, the economy. That's how I see things going forward.
National Chief, appreciate you taking the time. Thank you very much.
Thanks for the opportunity.
Perry Bellegarde in Vancouver. He is the National Chief of the Assembly of First Nations.